thank you for joining us here for the Knight Commission on Intercollegiate Athletics session, Overlooked and Changing Realities, What You Need to Know About the House Settlement. I'm Amy Privette Perko, the Knight Commission CEO, and we also want to thank all our virtual participants online today as well. As an independent leadership group, the Knight Commission often convenes higher education and college sports leaders to discuss pressing and new challenges. A couple months ago, we had a session with a large group of university presidents about the future of college sports. That discussion underscored that in many respects, the proposed House settlement is not well understood. In response, we developed this educational session along with an additional resource that we will share with you at the conclusion of this presentation. This presentation and the slides will also be available on our website, knightcommission.org. Before we dive into the main content, I want to take just a minute to share the Knight Commission's purpose and legacy for those who may not be familiar. From its inception, the Commission's work has been driven by values. Our purpose is to lead transformational change that prioritizes the education, health, safety, and success of college athletes. That's not just talk for us. The Commission has a legacy of influencing change to align incentives with values. Changes that included the creation of an academic threshold for postseason eligibility and the creation of more than $1 billion in national academic incentives. These reforms were major factors in the current record high graduation rates that Division I college athletes experience today. More recently, our efforts have influenced changes in national and conference incentives so that the value of gender equity is reflected in their policies and in incentive structures. For example, as you know, Division I members will be voting at this convention to establish incentives for women's basketball success in March Madness, similar to incentives that have been provided for decades for success in men's basketball. Now let's turn to the main focus of this presentation and the focus of college athletics today, the proposed House settlement. And before I hand it over to our panelists, a couple of disclaimers. This presentation and the related materials are provided from the Knight Commission's independent viewpoint and are not intended to replace NCAA resources. This information is also not legal advice. You will hear from Knight Commission consultants and one of our commission members. Several of them, like myself, worked in Division I athletics, collectively bringing decades of experience to this discussion from the institutional, conference, and national levels. We've walked in your shoes, and we know you're under incredible pressure in making decisions about how your programs will operate in this new and unprecedented era. Frankly, it's confusing. Maybe as confusing as navigating this hotel. I'm not sure. If you're participating online, trust us. Navigating is confusing. We're also pleased to be joined by Title IX expert and attorney Janet Judge, partner of the Education and Sports Law Group. In brief overview, let me summarize what the presentation will cover: the legal basics of the settlement, Title IX considerations, financial implications, Division I membership guarantees that the settlement does not alter. And from there, we'll discuss how opting in works, institutional considerations and impacts of opting in, and finally, Knight Commission member and former Division I Commissioner Amy Huchthausen will close the presentation with thoughts about impacts on conferences and broader changes that might occur. Former Power IV Athletics Director Todd Turner will make some concluding observations before facilitating our Q&A. And on that note, virtual participants, you can put your questions in at any time. Now to talk about the basics of the settlement, I will turn it over to Gabe Feldman, legal consultant to the Commission, Sheer Gardner, professor of sports law at Tulane University, and host of the excellent sports law podcast, SportsWise. Gabe?
Thank you, Amy, and thank you, everyone, for that warm applause. It is, yeah, no. Yes, that's very sincere. Thank you. It is good to be here. Thank you all for being here. Although I'm wearing a Tulane tie, not a Carolina tie, I am not up here representing the views of Tulane. Let me get into some of the basics of the House settlement. The House settlement terms were negotiated by the defendant conferences, which is defined as the ACC, the Big Ten, the Big 12, the Pac-12, and the SEC, as well as the NCAA leadership, and was then approved by the D1 Board of Directors and the NCAA Board of Governors in May 2024. Judge Wilkin then preliminarily approved the settlement back in October, and the settlement actually consolidates 3 antitrust cases, House, Carter, and Hubbard, and provides relief from claims that challenge NCAA rules restricting athlete benefits. The defendants estimated that their potential liability under these antitrust cases was tens of billions of dollars, including treble damages. The settlement covers 3 primary areas. 1, back damages of approximately $2.8 billion. 2, a new model for athlete benefits that will allow, but not require, institutions to provide athletes with significant financial benefits beyond those previously permitted, and also provide for greater opportunities for athletic scholarships. And 3, it will put in new requirements for all D1 athletes for third-party NIL compensation. Okay, let's start with the back damages of approximately $2.8 billion. This is to cover all Division I athletes who participated between 2016 and 2024 to be paid over the course of 10 years at approximately $280 million annually. An estimated 95% of those damages will be paid to football and men's and women's basketball athletes from the defendant conferences. The new model for college sports going forward. Under this new model, Division I institutions will be allowed to provide significant new financial benefits to athletes beyond those previously permitted. These new institutional payments include direct NIL compensation and additional payments and benefits. And those additional payments and benefits are commonly referred in the media as athlete revenue sharing. The NCAA documents and the legal documents themselves refer to these new payments to athletes as additional payments and benefits and pool payments. The cap for the first year for these additional payments and benefits is approximately $20.5 million. Now, the cap applies on an institutional basis, and there are no sport-specific caps. And you'll hear a lot more about the cap later on in the presentation. Institutions that provide new payments and benefits to athletes must also comply with new financial reporting and compliance processes. And it's important to note that the direct NIL payments from schools to athletes do count towards that cap, but they are not subject to the fair market value determination under the settlement terms that there's been a lot of discussion about, and I will talk more about in a minute. The new model will also create new opportunities for scholarships for college athletes. The new model allows, but again, does not require, institutions to provide more athletic scholarships in all NCAA sports by eliminating the current NCAA scholarship limits and replacing them with roster limits. So, for example, FBS and FCS football will have roster limits of 105, and women's soccer, for example, will have a roster limit of 28. Schools will be able to offer full or partial scholarships to every athlete on the roster. All institutions in the defendant conferences are subject to the changes I've just discussed in terms of athlete payments and roster limits. But all other Division I institutions, so all institutions outside of those defendant conferences, have the choice to opt in to the settlement terms. And Sandy will talk about that opt-in choice a little bit later. The settlement terms also establish new regulations that will apply to all Division I college athletes who receive third-party NIL compensation. Right? So this is not the direct NIL compensation from schools. This is third-party NIL compensation, regardless of whether their institution opts into the settlement or not. Right? These regulations apply to all Division I college athletes. These regulations, among other things, require college athletes to report any third-party NIL compensation that exceeds in the aggregate $600 to a designated entity. The settlement will also usher in greater oversight and a fair market value assessment of NIL deals between athletes and boosters, other associated entities, including collectives, to ensure that they are, quote unquote, legitimate NIL deals. Institutions can also facilitate NIL deals with third parties, including boosters and collectives. Now, there is no cap on athlete NIL compensation provided by a third-party entity, even if that deal was facilitated by the school. So just to sum up these two important distinctions, if the NIL is provided from the institution itself, if it's directly from the institution, it counts towards that $20.5 million cap, but it is not subject to any fair market value determination. If it is NIL compensation provided by a third party, it does not count towards the cap, but it is subject to the fair market value determination. It's very confusing, very complicated. There are a host of other requirements for college athletes. And so on December 23rd, 2024, Judge Wilkin approved a Q&A document specifically for athletes to help them navigate all of the changes on the horizon, but not in the hotel room, the hotel. This document, the joke worked once, I didn't need to make it again. Amy did it better. Okay. That document is available on the NCAA website and addresses some of the changes that I have previously outlined, including the big changes for athletes who will receive significant new payments and benefits directly from institutions, new regulations for third-party NIL compensation, and the potential impact of new roster limits on athletes. Now, the new NIL regulations are raising criticism from state legislators, particularly in states that have permissive laws regarding college athlete NIL rights. And notably, there are a number of unresolved issues that come out of the settlement. One of those unresolved issues is that the settlement does not resolve any conflicts that may still exist or may arise in the future between NCAA rules and state laws regarding NIL restrictions on college athlete compensation, provided either by the institution or by the third parties. The settlement also does not resolve the separate legal challenges about whether some or all college athletes should be classified as employees, and certainly does not cover whether some of these new payments or benefits might change the employee classification down the road. There are other unresolved issues, including, among others, that athletes have a right to opt out of the settlement and continue to sue for damages. People can object to the terms of the settlement, and there is also pending litigation challenging the settlement. The new model for athlete payments from institutions also raises potential new tax implications for athletes and institutions. Tax experts should be consulted for guidance. And there are a host of potential Title IX issues that are raised, which we'll talk about in a minute. So here are the key dates moving forward. Objections to the settlement and those athlete opt-outs must be filed by January 31st, so end of this month. A final approval hearing is scheduled for April 7th, 2025, and that if the settlement is approved by Judge Wilkin, the terms will go into effect on July 1, 2025, and continue through the 2034-35 academic year. And if the settlement is approved, NCAA bylaws will need to be changed to reflect and be consistent with the settlement terms no later than the settlement effective date of July 1, 2025. So I will now turn it over to Janet Judge, attorney and partner at the Education and Sports Law Group and the most prominent voice on Title IX in the country, who will discuss Title IX.
I got applause. Okay. Thanks, Gabe and Amy and the Knight Commission and all of you for coming to talk about a highly stressful topic. Today, I'm focusing on Title IX's application generally. Those of you who have seen me speak before will note that I am tied to notes here today because I want to especially get it right, and there's no telling what I may say when I'm off script. We're going to talk about the myriad ways the law could apply in the wake of the House settlement, provided the settlement is approved by Judge Wilkin. To be clear, I'm a lawyer, but I am not acting as your lawyer, providing legal advice or speaking on behalf of any of my clients here today. These remarks are mine only and are intended to prompt ongoing discussion around a very important piece of legislation. First, to state the obvious, we are in the middle of dramatic administrative transition with lots of discussion around how Title IX should apply in different spaces, including athletics. Setting aside anyone's viewpoint on the reasonableness of allowing athletes to participate consistent with the eligibility rules set for sports by their national governing bodies, the incoming administration and many members of Congress have frequently cited the importance of Title IX in ensuring equitable athletic opportunities for women and girls. It would seem inconsistent to then seek to upend the Title IX regulatory framework that has been in place since the 1970s. Title IX is a federal civil rights spending clause statute, as you well know, making gender equity an affirmative obligation upon acceptance of federal education dollars. It provides that no person in the United States shall, on the basis of sex, be excluded from participation in, be denied the benefits of, or be subjected to discrimination under any education program or activity. Intercollegiate athletics programs are education programs and activities subject to Title IX. Dollars that are awarded to athletes associated with their participation are related to these education activities and have always been subject to the law. In the athletics area, schools are expected to provide equitable participation opportunities, athletics-related financial assistance and treatment, including support and benefits provided to existing teams. All three Title IX areas are in play under the proposed House settlement. Roster limits impact equitable participation, increased athletic scholarships, and other financial payments funded with institutional dollars, notwithstanding their source, to the benefit of those who participate in the school's athletics program, and in some cases, their families arguably implicate both Title IX athletics-related financial assistance provisions and benefits and treatment provisions. In short, I believe the question is not whether Title IX applies, but rather how Title IX will apply in the space. While specific official guidance or judicial direction regarding the how is not yet available, unfortunately, creating a vacuum at a time of profound change and enormous stakes. And with the caveat that there is no telling what any individual judge will do on any given day or what legislative tweaks may be coming down, including those that have been discussed regarding employment carve-outs for college athletes. I've highlighted ways I believe Title IX would apply based on the current jurisprudence, administrative enforcement, and legislative history of the law. In other ways, it might apply if the House settlement agreement is approved in its current format, depending on how schools may choose to implement its provisions. The proposed House settlement sets roster limits for NCAA men's and women's sports. Schools may populate their programs with squad sizes that are equal to or fall below the sports-specific limits starting in the fall of 2025. As a result of the participation numbers at most schools will change, in turn will impact their participation equity position. Because provisions in settlement agreements do not exempt schools from otherwise meeting their Title IX obligations, programs will still be required to comply with at least one of the law's 3 participation equity tests. This will particularly impact schools that are not able to show prong 1 compliance, in that their participation numbers are aligned with their undergraduate enrollments by gender. Athletic scholarships also face similar challenges. The proposed House settlement waives current NCAA scholarship limits for those schools bound by the agreement and allows programs to offer as many or as few full or partial scholarships as they please and are able to fund for athletes on their teams. At the same time, Title IX will continue to require athletic scholarships to be awarded in proportion to the percentage of men and women who participate in the school's athletics program, the unduplicated count, and not the undergraduate enrollment numbers, as has been widely and mistakenly reported. Current Title IX guidance allows for 1% or less disparity between the percentage of male and female athletes and the scholarships awarded by gender, absent a narrow set of non-discriminatory defenses, none of which include revenue generation. Above and beyond athletic scholarships, the settlement provides broad latitude to schools to decide if and how they will allocate up to $20.5 million in institution fund payments to athletes for their NIL, brand endorsement, or other types of permissible services. While there will be reporting mechanisms to ensure that school payments do not exceed the established fund cap, there is no obligation under the House agreement per se for schools to prove to the NCAA, their conferences, or the plaintiffs' counsel that the institutional payments to athletes reflect fair market value for their services purchased, or that rather if there's any quid pro quo involved at all. Even so, schools that seek to defend their payments against legal challenges pursuant to civil rights laws and other laws external to the House settlement agreement, including Title IX, will likely need to be able to show their work, including by backing up their valuations and any non-discriminatory justifications for any gender differences in the value and relative allocation of these opportunities. Currently, there seems to be a merging of the concept of athletics market value with the NIL value an athlete may bring to market a program. This is an area that I believe will get intense scrutiny if and when legal challenges are brought. Per school statements and news reports, most FBS schools are evaluating industry standards, competitive priorities, and legal risk when determining how they might distribute their funds to athletes. In my opinion, past damages award allocations per se are not an appropriate measure of future Title IX compliance standards. Past damages allocation decisions have been made by plaintiffs' attorneys and their experts according to their valuation of the individual antitrust claims of their clients under each of the cases at bar, none of which include any Title IX claims. Accordingly, Title IX does not govern how the plaintiffs' attorneys have allocated these past damages. And in short, attorneys Kessler and Berman have stated in court that they are not required to consider Title IX in this context, and they have not done so. As such, the framework should not be relied upon as setting the standard for satisfying an individual school's Title IX obligations moving forward when considering prospective fund payments allocations without an independent Title IX analysis. Similarly, there's been no court blessing of the framework under Title IX. At the preliminary approval hearing, Judge Wilkin explicitly stated that she is not reviewing the settlement terms with an eye towards Title IX compliance. The judge's limited discussion of Title IX focused on whether the agreement has language that clearly informs participating athletes of the legal rights they may be waiving by participating and choosing not to opt out of the agreement, including their rights under Title IX. And while plaintiffs' counsel seemed to assure Judge Wilkin that the athletes' Title IX rights would survive, the red line version of the settlement agreement subsequently filed with the court clearly states that Title IX rights are waived, but only as to back damages. Both the preliminary approval hearing and in the press, attorneys for both sides have stated that individual institutions are responsible for determining how to implement the prospective House benefits in compliance with Title IX and other non-antitrust laws. So how might Title IX apply to fund payments moving forward? It's been a longstanding tenet of Title IX jurisprudence that revenue sports and the gross revenue associated with these programs are not exempt from Title IX coverage. This is true notwithstanding multiple legislative efforts to carve out revenue exceptions, including those made at the time the law was passed and throughout its 52-year history. Similarly, administrative and judicial bodies have uniformly held that revenue production associated with any one sport does not justify disparate participation, financial assistance, or treatment directly benefiting men's and women's teams and male and female athletes overall when funded using institutional dollars. The law's treatment of sport-associated revenue is not new, requiring equitable participation, financial assistance, and treatment funded by dollars that may come into a school as a result of a media rights agreement, ticket sales, game guarantees, or private donations has always been in place. In short, once the dollars come into the school, they become school funds, and the benefits they provide are subject to federal law. As reported by ESPN, an official at the Office for Civil Rights, who is, I will agree, on the way out, has stated, as has been true all these decades, Title IX requires schools to ensure that when accepting and using private donations, schools do not create disparities in benefits, opportunities, and treatment on the basis of sex that result in the denial of athletic opportunities. Schools have stated publicly that they will seek new streams of revenue to fund these payments, and the impacts may be seen already. The prospect of making tax-exempt donations to schools at the same time the IRS has signaled that it will not extend exempt status to donations made to most collectives is a reason many collectives may soon go away, and why schools will get the benefit of those past payments. In addition, some schools have stated that they are exploring avenues to shift existing internal dollars to their revenue sports by tiering programs as well. Unless courts create a wholly new application of Title IX that ignores the current rules concerning how allocations of financial aid and financial assistance dollars are evaluated, or otherwise determine that the fund payments are not athletic-related financial assistance, it is likely that Title IX will continue to be interpreted to require payments characterized as rev share, market share, or simply fund payments without more to be allocated proportionally absent viable non-discriminatory reasons. In cases where the fund dollars are allocated by sport as discussed above, it remains to be seen how athlete agreements will be evaluated under Title IX individually and in the aggregate. Title IX has never required schools to provide individual athletes with equitable support, scholarships or otherwise, but rather allows for disparate benefits provided there is equity overall as to the men's and women's programs. If the individual allocations are not supported by non-discriminatory factors, however, we may see individual challenges around the equity of individual NIL agreements as to male athletes as compared to female athletes or other areas of other protected classifications. Questions remain whether Title IX may require that institutional dollars used in this way be apportioned equitably by gender prior to distribution, likely resulting in differing numbers of men and women benefited, whether the law may be interpreted as requiring an equitable percentage of men and women that are benefited with NIL agreements, likely resulting in differing dollar awards in the aggregate based on objective and defensible fair market valuations, or whether the courts may punt and just find a whole new way of applying Title IX in the space. At the baseline, schools should be able to defend their disbursement strategy and individual payments based on objective NIL valuations. Title IX's 1979 policy interpretation, recently endorsed by at least one federal court when asked to ignore its provisions in the wake of a Supreme Court opinion giving courts greater autonomy when interpreting federal laws, states, when financial assistance is provided in forms other than grants, the distribution of non-grant assistance will also be compared to determine whether equivalent benefits are proportionally available to male and female athletes. A disproportionate amount of work-related aid or loans made available to members of one sex, for example, could constitute a violation of Title IX. In any event, absent finding of athletic employment or some new legislative carve-out, it's very unlikely that Title IX would permit a policy that seeks to award dollars to athletes based on their market rates without any accounting for gender that would likely apportion the lion's share of dollars to a significantly disparate number of men. In addition, plaintiffs' attorneys have already signaled their intent to challenge reliance on what has been described by them as a discriminatory market. If purchasing the non-exclusive NIL or IP or brand ambassador rights from their athletes only to warehouse them and without using them at all or requiring athletes to do anything in exchange for the payments, schools may also face claims that their compensation system is simply a pretext for disparately apportioning fund payments to men. In short, any distribution of these dollars will be examined both around the method of allocation and the resultant impact on the school's athletics program. For example, if a school's allocation of dollars is found to be equitable, but then has a disparate impact on a school's provision of publicity or recruiting support for its programs, Title IX's treatment components would trigger. Finally, schools are required to provide equitable treatment, as I just mentioned, benefits and support for the men's and women's athletics programs overall. So let me just give you a couple of examples of how this payments may impact that. If you talk to most coaches, they will talk about these dollars as recruiting dollars, as dollars they're using to attract students to their programs and then to retain them within their program. And that way, it would be fair to characterize them, at least in some contexts, as recruiting dollars through the eyes of the coaches. Title IX requires that men's and women's programs be provided equitable recruiting support, including financial incentives. And to date, OCR has relied on language contained in the 1979 policy interpretation that has stated that recruiting budgets for men and women overall should be equitable, absent clear and objective non-discriminatory reasons for any disparities. And then the last example, if an agreement results in 80 to 90% or more of the dollars allocated to male athletes to promote their program, for example, it's easy to see where the Title IX publicity disparities might exist, because then you will have 80 to 90% of your resources dedicated to promoting the men's program. And while we could talk for days around the possible Title IX implications, I think I've probably increased the anxiety in the room enough for now. And in the interest of time, I will turn the mic over to Peyton to talk about some interesting numbers. Thank you.
Now you guys are just rubbing it in Gabe's face. Thanks, Janet. I'm excited to be with you all this afternoon. I'm Peyton Barish, Coordinator of Policy and Special Projects for the Knight Commission. This portion of the presentation will examine Division I revenue and the potential impacts of the new model of athlete benefits that Gabe described across Division I institutions. The data you'll see comes from the Knight Newhouse College Athletics database, drawing from NCAA membership financial reports across nearly all Division I public institutions. During this presentation, and as Gabe mentioned earlier, the 5 conferences known as the Autonomy or the Power 5 at the time the House lawsuit was filed will be described as the defendant conferences. This presentation shares 3 key graphs that compare the finances of the institutions in non-co-defendant conferences to the defendant conferences. This graph shows the median total revenue in fiscal year 2023 across 4 different NCAA Division I subdivisions or groupings. These groupings are, from left to right, the Autonomy 5, which again are the defendant conferences, the Group of 5, which are the other FBS conferences not in the Autonomy group, the Football Championship Subdivision or FCS, and the remaining Division I institutions that are basketball-centric. There are a couple of things to highlight. First, the median athletic department in the defendant conferences has $100 million more in revenue than the median Group of 5 athletic department, and $125 million more in revenue than the median FCS and Division I basketball-centric institutions. It is just as vital to note that this gap will grow much, much wider because the defendant conferences will soon receive a massive influx of revenue from the expanded college football playoff and conference media rights deals. Meanwhile, institutions in the other groupings will not experience a similar windfall. The widening of the gap represented in this snapshot will only accelerate in the future. This slide has the same total revenue for each group as you saw on the last slide. These data are presented to illustrate different categories of revenue as a percentage of total revenue. These revenue categories are represented by different colors as shown on the right. A quick scan of the colors represented in each competitive grouping highlights the very different funding sources. We will not discuss each revenue category, but it is important to highlight that maroon and orange represent revenue from institutional and government support and student fees. The median institution in the defendant conferences, shown in the left column, received only 2% of its funding from institutional and government support and student fees. Comparatively, the other Division I median athletic departments relied on institutional and government support and student fees for 60 to 76% of their funding. This significant reliance on institutional support and student fees to support between 2/3 and 3/4 of their annual budgets underscores the different financial world in which the non-defendant conference institutions operate. As demonstrated on the graph, the institutions in the defendant conferences generate most of their money from media rights, particularly through distributions from their conference, the college football playoff, other football postseason events, and the NCAA, which are all shown in light blue. Donor contributions are shown in green, and ticket sales, represented in purple, display a noticeable difference from the other groupings. The differing sources of revenue raise a critical question for athletics programs that already rely heavily on institutional funding and student fees and are not expecting any new windfall of generated revenue. If those programs choose to opt into the House settlement and provide new payments to athletes, where will this funding come from? This last slide examines the institutional cap on new athlete payments and enhanced benefits and how the cap is calculated. As Gabe said at the beginning of the presentation, the institutional cap for the initial year is projected to be $20.5 million, as highlighted in the red box. The calculation for the institutional cap includes data from 8 detailed revenue categories reported on institutions' NCAA financial reports. Our analysis combines the data from these categories into 3 buckets of generated revenue that are described in the legend on the right. Sponsorship and advertising are shown in dark blue, conference, NCAA distributions, media rights, and CFP distributions are shown in light blue, and ticket sales are shown in purple. The formula calculates 22% of the average revenue from these categories for all institutions, public and private, in the defendant conferences to determine the institutional athlete benefits cap. This institutional cap will be recalculated every 3 years and includes any new conference members in that calculation. The cap also increases by 4% annually. As you can see, our data for athletic programs at public institutions in the defendant conferences shows that the median institution generated $90.4 million in those 3 categories. It's important to point out that this slide is based on fiscal year 2023 data, and these revenue categories are expected to increase with the expanded CFP, which will see its contract nearly double compared to the current contract. While this institutional cap is created using the revenues from the defendant conferences, institutions outside of the defendant conferences that opt into the settlement terms are bound by this same institutional cap. This graph now includes the median institutions in the other Division I competitive groupings and their revenue from the same 3 categories. Again, the median institution in the defendant conferences generated more than $90 million from these revenue sources. Compare that to the other 3 groupings. The median institution in the group of 5 generated $8.1 million. Move to the median FCS institution, and it drops to $2.4 million. And the median Division I basketball-centric institution generates $1.4 million from those same revenue sources. These differences again emphasize that the settlement and institutional athlete benefits cap was designed for the defendant conferences. Non-defendant institutions that opt into the settlement do not have a different institutional cap, but individual conferences could independently adopt a lower cap for their conference institutions. That could allow individual conferences to help their institutions maintain both financial sustainability and competitive equity with their conference peers. These visualizations highlight the financial realities that are central to navigating this new era of college athletics. Now, to speak about the other institutional impacts of the proposed House settlement, I would like to introduce the Knight Commission's Managing Director for Strategic Initiatives, Sandy Hatfield Clubb.
Thank you, Peyton, and hello to everyone. No surprise that the most consistently expressed concern from the non-defendant conference institutions is to retain access to championships and shared athletics revenue. As a former Division I FCS athletic director, I recognize the impact that it would make on student athletes, coaches, staffs, institutions, conferences, if they lost the opportunity to play for what everybody is playing for. And that's an opportunity to be in the NCAA championships. The good news here is that Division I membership standards and those ensuring access to NCAA championships are not impacted by the settlement. Furthermore, access to NCAA revenue distribution is not impacted by the proposed settlement itself. Division I members are guaranteed access to Division I revenue under the formula updated in January 2022. Access to Division I championships and NCAA shared revenue are governed by division dominant bylaws, which require a 2/3 vote to change. The bottom line here is that Division I institutions have a vote in determining access to Division I championships and how NCAA revenue is distributed. For example, this afternoon in the Division I business session, all Division I members present will have an opportunity to vote on a change to the NCAA revenue distribution plan to determine whether a women's basketball performance fund will be added. Approval requires Division I members, a 2/3 vote of Division I members. So to be clear, the settlement itself does not change access to revenue or championships for Division I members, including institutions that do not opt in. Opting into the House settlement is a choice for all non-defended institutions. May not feel like that, but it is a choice. There are 3 ways to trigger opt-in status, and we'll provide some guidelines around that in just a moment. But first, an institution can formally opt in to the settlement. It is also important to note that institutions would kind of de facto opt in and would be required to comply with all settlement terms across all sports if any form of new payments to athletes were provided to even one athlete, or if athletic scholarships exceed the current NCAA scholarship limits in even just one sport. As Gabe mentioned earlier, opting in means that roster limits are applied to all sports. And now to provide a few guidelines related to the choice to opt in, the NCAA has established an annual March 1 deadline, a declaration date for non-defendant conference institutions beginning in 2025, which, as we know, is just 6 weeks from now. Institutions are required to opt in, are not required to opt in during year 1 and can opt in at any of the 10 years over the settlement period. An institution may opt in during 1 year and actually can opt out in later years, but they would have to return to any pre-house athlete benefits and team scholarship levels. Institutions that do not opt in must abide by pre-house NCAA rules governing athlete benefits and current scholarship limits. And these athletic programs are not subject to roster limits. Institutions that choose not to opt in may be in a position to expand current benefits, such as increasing scholarships and/or providing Alston funds if those institutions are not currently meeting the maximum allowable limits. So increases within the current pre-house allowable limits are permitted. The consequences of opting into the settlement should be weighed with great care, since there can be far-reaching implications that extend beyond the athletics program. We offer a number of important factors, and I'll highlight just a few of them here. The first is the overall financial impact to the institution, and as the financial data demonstrated by Peyton, that institutions from non-defendant conferences across all 3 NCAA divisions rely heavily on institutional support and student fees. Funds needed to provide new payments and benefits to athletes may create a larger burden on institutional finances and on its students. Within the athletics department, the choice to opt in will place additional stress on athletically generated revenue, such as donor contributions, and require a redistribution of funds within the athletics program. Pressure to prioritize new athlete payments and benefits to some athletes, most likely basketball and football athletes, have raised concerns from athletes, coaches, and administrators alike that opportunities and treatment for other athletes may be diminished, particularly in Olympic sports and the non-revenue producing sports. Diminished opportunities may also occur as a result of roster limits. And as Gabe mentioned earlier, roster limits will be required across all sports, even if new payments and benefits are provided to a single sport or an individual athlete. On some campuses, these roster limits may have very little impact, while on others, the loss of opportunities could be significant. On some campuses, a loss of opportunities may also significantly impact enrollment growth and student diversity strategies. Given the current scholarship limits, roster spots that are cut are very likely from tuition-paying students. As reviewed earlier, Title IX compliance is an important consideration as changes are made to financial support, benefits, treatment, and opportunities to student athletes. To wrap up, I want to share that the Knight Commission does not place a value judgment on the decision to opt in. Given the potential institutional impacts, we recommend that institutions approach this decision with caution, very carefully considering it against their institutional values and mission. So now I'd like to introduce one of our Knight Commission members, Amy Huchthausen. Amy is the Chief Operating Officer at Stavvy, and her former position as Division I Commissioner of the America East Conference gives her unique perspective on the challenges that D1 administrators are facing today. Amy?
Thanks, Sandy. Conference leaders have been evaluating the potential impacts of the House settlement and related decisions on their member institutions, as well as the broader future of their conferences and the role of conferences in this new era. I'll highlight a few key implications for Division I conferences now. First, while opting into the settlement is an institutional decision as has been repeated earlier in the presentation, conferences have the authority to establish independent policies for their members, as Peyton noted. There are multiple Division I conferences that expect some, but not all of their institutions to opt in. This evolving situation could result in institutions within the same non-defendant conferences operating under different rules. For example, some will follow roster limits, while others will maintain current scholarship limits with larger rosters. Additionally, some institutions may provide new payments, while others will not. These variations in rules within conferences will create and perhaps accelerate both unique and consistent or persistent competitive, administrative, and alignment challenges, thereby spurring another round of conference realignment as institutions more closely assess with whom and how they want to align and compete. You've heard from other panelists about some of the tangible ways the proposed House settlement will drive historic change and fundamentally redefine Division I. As we look ahead, the Knight Commission is keenly interested in just how expansive the proposed settlement will be as a catalyst to more substantive change in Division I governance, conference realignment, and perhaps even federation of sports as a new way to organize competition. As a reminder, this is a new game that has not even started, and so we are all eager to see how it will unfold. On that happy note, I will now turn it over to another of the Knight Commission's expert consultants, Todd Turner.
Thank you, Amy. As previously mentioned by our host, Amy Perko, I am a former FBS Athletics Director, having served in that role in 3 different of the defendant conferences. So I've got some history in this game, and I understand the challenges and the difficulties that you face as institutional leaders when it comes to these things. I wanted to share a couple of observations with you. With the adoption of the settlement, implementation will go from an abstract concern to reality. As former campus practitioners, we really know how incredibly challenging this will be. Opting in will mean different things to different schools. Is it a competitive requirement? Is it a branding opportunity for your institution? Will it lessen your institution's ability to provide equitable experiences to your student athletes? Will opting in raise the cost of education for all students and add unsustainable costs to your institution? How will institutions outside of the Power Four address the reality that their athletics programs operate in a very different financial universe, as you saw from Peyton's demonstration? And most importantly, how will your institution operationalize the new framework with continued priority on the values of education, gender equity, and opportunity? The Knight Commission urges all Division I presidents, athletics directors, and governing boards to move thoughtfully through implementation. For those institutions with a choice to opt in, we further urge you to carefully consider and address those questions that I just raised, and especially to evaluate your decision, to evaluate that decision to ensure that it is consistent with your institution's mission, its values, and also its financial wherewithal. The Knight Commission has prepared a resource on the House versus NCAA settlement. It's available by accessing the QR code shown on the screen, and the link will be emailed directly to all participants registered for today's session. It is also available on the Knight Commission website, knightcommission.org. We'd like to hear from your feedback and take some questions from both from this room and also from our online guests. You may direct your questions to any of the presenters. If you're participating virtually, please utilize the Q&A function and share your questions or comments. For our in-person guests, please use the microphone that is to my left and also share your name and affiliation. So with that, I'll open the floor. Do we have any online questions?
We do. Todd, I'm going to combine two questions, one from Rand Sachs and other from Dave Ford regarding third-party NIL. And Gabe, regarding fair market value assessments, are all third-party deals subject to the review or just agreements with third parties who are associated individuals or entities with a university? I'll let you answer that one. And then secondly, what happens if an athlete does a third-party deal and is determined to not meet fair market value? What's the outcome of that?
Okay, first one first. There is a distinction. The fair market value assessment is for third-party deals with associated entities, including collectives and boosters, not with other entities. And even if you are a booster or associated entity who owns a company, if it is a publicly traded company, and you are offering services to the public, that's not subject to the fair market value. So there is some restriction on who the fair market value determination applies to, but it is not intended to apply to the non-associated or affiliated third party. The second question, what happens if the other third party, the third party entity that's designated to review these third-party NIL payments, what if they determine that it is not a fair market value payment? I think that is still a little bit to be determined. I think the spirit of it is not to impact the athlete's eligibility or to punish the athlete, but to void the deal. And I suppose it's possible they could rework the deal, but that the deal just wouldn't be allowed and the athlete wouldn't be able to receive that payment. Janet,
There's also arbitration provisions in
Right,
there so that there's an opportunity to have a back and forth around it. There's also a provision in there that allows the student athlete to seek assistance in determining whether or not a deal will meet fair market value. So there are provisions built into the agreement that are student friendly that are intended to try and get at this particular issue.
Go to the microphone.
Thank you. I'm Matt Brown. I published the Extra Points newsletter. Had a question that might be for Gabe, but anybody could chime in if they know. I regularly receive questions from my readers about the handful of institutions that may compete at the Division I level in just one sport, but otherwise compete in Division II or Division III, like with men's hockey. I'm wondering if those institutions are permitted to opt into this settlement for the purpose for only the sports where they compete in D1. And if they do that, what does that mean for the sports or their obligations for the rest of their athletic program?
Our discussion right here was which one of us was going to sort of make it up as we went along. Well, the roster limits and other things apply at the Division I level, right? They're not applying outside of that. I would also say if you only have one Division I sport, you might want to check some Title IX issues that might be involved there. But I think it's a fair question, but I would imagine that if you're opting in for that one sport, it's that one sport only, but I could be wrong.
I would agree. I mean, I don't know the answer to it. And I think there are a lot of questions floating out there that don't necessarily have answers yet and are still being worked out, because this was the framework we're working with is an antitrust settlement, not a create new rules for the future of college sports. And so those creating new rules for the future of college sports are still a work in progress and trying to figure out how they fit into the settlement and how many things are dictated by the settlement itself versus how many things the NCAA and the institutions have to decide for themselves. And so I think a lot of those are still TBD.
Also, there would be some opinions, I imagine, by other Division I members if you're then arguably able to give $20.5 million to that one particular sport. So imagine there will be reactions to this. And then also I would say all of the other Title IX issues we talked about are still in play too, because Division II and Division III do not allow you to do these sorts of things. But Title IX doesn't recognize that as a non-discriminatory reason for giving $20.5 million to one team that's at the Division I level.
Can I just add there? I'm sure this will be the first question addressed in the updated Q&A doc that the NCAA may send out, or at least we would hope that would be addressed. But I did want to point out the resource that we're making accessible is a brief that we combined the NCAA's Q&A doc with all of the other accessible resources to try to create a more narrative to explain the settlement.
Take another question.
Hello, my name is Sally Roberts. I'm the CEO of Wrestle Like a Girl, the national advocacy organization for girls and women in the sport of wrestling. We've been driving forward to get women's wrestling to championship status. That vote is going to be happening this week. Thank you all for your support in advance. The question that I have for you is, as we've approached Division I institutions about the feasibility and the opportunity to add women's wrestling as a varsity sport, we get the feedback that right now the current landscape is really looking at the NIL. And because Title IX is not enforced, they've asked us to step away so that they can understand that landscape before the enforcement of Title IX comes into play. What advice would you give to emerging sport leaders like myself as we continue these conversations, knowing that there is a balance between NIL and Title IX, and we want to be able to support the ecosystem as a whole?
Who wants to take that?
She said Title IX, so we'll turn.
You can
to
wrestle. You can wrestle with your answer here. That's be good.
Well, a couple of things. One, recognize the amazing job that you've done and how women's wrestling has just exploded across the United States. So congratulations. I remember speaking with you a couple of years ago when you were just getting it going, and what you've done in just a couple of years is just tremendous. I mean, Title IX is alive and well, and there are a number of Title IX lawsuits in play currently. The OCR enforcement has, you don't always know about all of the enforcement efforts that are going on out there. We do also have NIL at play in one lawsuit that is out there right now, and I think they will probably pop up in other lawsuits. But, right, I think, in terms of discussions in the space, I think putting the facts out on the table, and then the institutions are weighing a whole wide variety of competitive equities, pressures, and concerns. And I think just getting the information out there and that compliance with the federal law is not discretionary. It's not discretionary.
And I would just add, I don't know why it is. I think there may be multiple explanations, but we don't ask, do you have to comply with contract law or tax law or intellectual property law? We only say, do you have to comply with Title IX? It seems like, and Title IX is the only one that is thrown up there as an obstacle to progress. And yes, you have to comply with federal law, as Janet said, but that doesn't mean you can't do things. You can't make progress. You just have to make that progress within the confines of Title IX. And Title IX exists for a reason. And it continues to need to exist for a reason. And so I think it is just really problematic to use Title IX as a reason to not promote and provide more opportunities for female athletes. And so I just think, again, I'm sitting next to the person who's done more for this than anybody else, I think, in the country. But just to stop using Title IX as an excuse to not do things. Or at least maybe start using other areas of law too. But again, why are we treating Title IX so differently than everything else?
One thing
Someone started to applaud, so I want to let
that's for you. That's for you. And I would say though, in defense of some of these programs that I have spoken to, they're looking for the fallout of the roster limits, of whether or not this agreement actually goes forward, before they're making significant decisions about sports sponsorship. So I would not say this is a moratorium on discussions, but it may be a little bit of a let's wait and see in the next couple of months. But I'm sure you're on it and we'll continue. So great question. Thank you.
We're at the end of our hour, and I want to thank our very learned and expert panel for their humor and their contributions to today's discussion. I also want to let those that submitted questions online know that many of your questions can be answered in the supplemental materials that we will be sending to you or that have been presented today. And if they are not, we would try our very best to get back to you with an answer. So thanks for your attention today and enjoy the convention.